We are live and on the record.
Okay, good morning, everyone. Welcome to the Appeals Court. My name is Amy Blake. I will be presiding over this single justice matter today. It is docket number 2021 J0470, Federal National Mortgage Association versus Anthony M. Branch. Prior to going live, we had a discussion, and the only issue today is an appeal pursuant to Chapter 239, Section 5, the so-called appeal bond. Mr. Branch has agreed to withdraw his motion to waive transcript costs. Is that correct, sir?
That is correct, Your Honor.
Okay, so when you begin speaking, the clock will start, and I'll hear from you, Mr. Branch, when you're ready.
Good morning, Your Honor, and good morning to my stepbrothers, Thomas and Attorney Stearman. I'm not a member of the bar, but we've been arguing this case for the last couple of years. Respectfully, Your Honor, I'm here on the bond appeal, and if just a little patience from the court, because of my neurological disability, I'm going to have to really rely on the papers and refer to my notes here. Your Honor, my position. Thank you, Your Honor. My position is this is a post-foreclosure case where there appears to be a procedural bar with respect to use and occupancy to be given to this third party. Specifically, Mr. Cardoso is a third-party purchaser who knew from the offset that there was pending litigation with respect to this case. Mr. Cardoso started his own summary process action in the lower court. In that particular summary process action, he never requested use and occupancy, nor did he ever amend his complaint. Mr. Cardoso was represented by able counsel, two members of the Massachusetts bar, yet he decided to dismiss his summary process action instead of seeking again use and occupancy. There was a flurry.
Hold on a sec. Was he awarded possession though of the property?
He was not, Your Honor. The case was, he dismissed this case on, I think, Rule 41.
So who has been awarded possession?
Fannie Mae.
Okay.
During the time of Mr. Cardoso's case, my case with Fannie Mae was still pending in the lower court. Respectfully, if I'm off on the dates, I believe that there was I think he purchased, he titled the home in between December of 2018 and February. There were hearings with respect to the use and occupancy. The use and occupancy was set initially by Judge Edwards at $1,800. Justice Blake reduced it down to $500. I began to pay that amount. Your Honor, specific to what I'm trying to allude to with respect to the bond issue, while we were in the appeals court, there were a flurry of motions to dismiss, both in the appellate level and both back at the lower court. You will note from the docket and you will note from the procedural history, my apologies to you, but I think I just wanted you to look at it. The procedural history on this case is very, very heavy. But with respect to the—
Can I ask you a question then? Is it your position that, well, maybe it's two positions. Is one of your positions that they're not allowed to have a use and occupancy payment? They're barred from that. But even if they were, $1,000 a month is too much.
Those are the two issues. Correct.
Okay. So hypothetically, I haven't made a ruling here. Let's say I disagree with you about use and occupancy being barred. What do you say is a reasonable monthly payment?
Oh, Your Honor, I will remain, as my papers indicate, with the 500. I mean, my goal is to vacate the order, but I would remain. I'm in agreement with Judge Blake, Justice Blake. The amount should, excuse me, not Justice Blake, the other justice. The amount would have been set at $500. That's the amount that I was paid.
Okay. And it got changed to $1,000 in September of this year. Is that right?
Well, see, now that's where the challenge comes in terms of legality. One of the things that Counsel Stammen has said, it's like a reinstatement, and then I hear from this court it could be considered a change. My thing is, if it's a change, it is not legally attainable because the order was vacated by the plaintiff. And see what we have here procedurally is Mr. Stammen's client decided to become the plaintiff, and it's, Your Honor, respectfully, case law is clear on this. If he's a plaintiff in terms of intervention, he's a plaintiff as the case has presented, based upon the prior decisions of the other litigant. He doesn't get a second chance. He doesn't, unless he starts his own case. And my—
Okay, so let me interrupt you again for a second. Would you agree that there is a judge's order, which is what I think brings us here today, on September 15th of 2021, setting the use and occupancy at $1,000 a month?
Yes.
And up until this order, were you up to date on your $500 a month payments?
The $500 a month payment was vacated, Your Honor. That's my point.
Okay, but before it was vacated, were you up to date on it?
Yes.
Okay. Okay, please continue.
Your Honor, what my argument is my argument is that there just needs to be a fairness in the process. I see I have 9 minutes left. I'm just looking. Fairness in the process, Your Honor. Bottom line here is that whether it is whether it was 1,800 or 1,000, in order for me to have successful access to the court, right of access to the court, my suggestion is that we operate consistent with the decision that was made in the majority. That, you know, incomes looked at, disabilities looked at, condition of properties looked at. Again, to your question, Your Honor, I was paying the $500 and didn't make an issue because the appeal needs to be processed. But that doesn't take away the procedural history. And what frustrates me just a little bit is that, you know, I'm a pro se litigant. And I truly believe this, and I love my judiciary. But if in fact you have a order that has been vacated as a matter of law, it's void. And the only thing that I'm asking as a pro se litigant is that the same standard apply to me as if I were a member of the bar with respect to Mr. Thomas or Attorney Stanman. Your Honor, again, my argument in writing is replete on what my thoughts are. I apologize for pausing, but I think that I don't know how much more I can offer to this argument, only to say that a vacate order is a vacate order. My position with the lower court that it could never exceed more than what the appellate court had ordered at $500. It appears that the housing court would be changing an appellate order if we look at this as being a valid or sort of a change, if I'm making any sense in my argument. In addition to that,
I understand your argument. Do you think that you have to vacate the premises at some point? Or do you still think you're lawfully present?
I believe that the eviction was clearly illegal. That's why I'm fighting it. But if we remain at the $1,000, yes, I will have to. I don't have $1,000 a month to give to Mr. Stanman, and I think, you know, respectfully to both counsel, I think that that's part of what's happening with us, with the former owners. Folks know we don't have 30. He also requested a $33,000 bond. Folks know we don't have that money, so the quickest way of getting anybody at the house is to make sure that the bond is so unreasonable that they would have to extricate themselves from the premises. Your Honor, in addition to that,
so Mr. Branch, you have to do two things, right? You have to show what you can afford, and I have that in your papers, and it's helpful today to hear from you. But the second thing I have to think about on this very narrow issue is your meritorious claim. So can you try to tell me as succinctly as possible why you think the eviction was illegal?
Sure. So, Your Honor, I guess respectfully to the court, my understanding is that we have to revisit that because the housing court has already made, and the prior justice has made that my claims are meritorious. So I need to do that again?
Well, no, my question for you is, I know that there was a panel of this court that issued a decision in your case, right?
Correct.
And now there is, at least as I understand it, a judgment for possession. And I guess you're saying that, well, maybe you're not. Are you saying that the eviction is illegal because a panel of this court has already decided the case in your favor?
No.
Okay.
This case is on appeal. It just went up to the panel based upon a motion that I made to docket the appeal. I've been trying to get this
Right.
to the appeals court for the
I saw
last
that.
15 months. It's been
I saw that.
Justice, what I'm asking is that a justice of this court and the two housing court judges have decided that I have non-frivolous appeal. Are you asking me to explain it to you again? That's
In a very succinct way, tell me why.
Yes, Your Honor. I'm going to argue on appeal that the notices weren't not compliant with respect to the notice of default. I'm also going to argue that the mortgagee was Fannie Mae, not Pentagon Federal Credit Union. The cure notices were faulty. I'm also going to argue that with respect to the work that was done in the bankruptcy court, a contract had been created that they would not sell my home, and that the affidavits of the attorneys that were involved in the case should be stricken. And there's a whole host of other things, but that's the ones that just stand out to
So
me.
that helps because that distills it down for me to sort of the component part. So that's helpful. You still have 4.5 minutes. I'm happy to listen to any other arguments you'd like to make.
Thank you, Your Honor. Your Honor, in closing, I would like to just refer to my papers because I write better. Your Honor, respectfully, the defendant requests no use in occupancy based upon the procedural histories and the rules of civil procedure in which Mr. Stammen did not follow. With respect to exigency and the actual property's value, I'm sure that the court would consider that. Your Honor, I do not believe that the order of the housing court is valid because the housing court in effect has re-looked at a case that a single justice has already made a ruling that the use and occupancy could not exceed $500. In addition, Your Honor, as a part of the use and occupancy order, a matter that was not in front of the court, and I'm asking directly that you vacate, was to give Mr. Cardoso access to my home. Your Honor, that matter wasn't before the court. I wasn't heard on that particular matter, and quite frankly, I don't think that was fair. Your Honor, the housing court's order appeared to have a conclusive presumption that Fannie Mae and Mr. Cardoso are going to win on appeal. That makes me very uncomfortable, but I don't think that's the way we should operate. The message should be very clear that we have appellate rights, and I'm attempting to fully use my appellate rights. No one wants to stay. If I'm here illegally, I don't want to stay in this house without paying use and occupancy. As indicated on the record, as indicated in the docket sheets, I started to pay the $500. But on the other side of that, Your Honor, I don't want to have such a use and occupancy penalty, a penalty that causes me to lose my right to an appeal. Justice Blake, thank you for your time.
Thank you, Mr. Branch. That was very well presented. Thank you so much. So next, we're going to have Mr. Stammen for 13 minutes. Let me just make sure that our clerk is ready.
Thank you for unmuting. We are ready, Your Honor.
Thank you very much, Mr. Emmons. Mr. Stammen, when you begin speaking, the clock will come up. So when you're ready.
Good morning, Your Honor.
Good morning.
I think clarifying exactly what's transpired here is important. Mr. Branch was foreclosed upon sometime prior to June of 2017. On June 12th of 2017, Fannie Mae commenced the summary process action against him. In March of 2018, the housing court entered judgment for possession against Mr. Branch. In April of 2018, a hearing was conducted on what Mr. Branch should pay for use and occupancy, and it was ordered that he pay $1,800 a month for use and occupancy based on the market value of the property. In or around April of 2018, Mr. Branch filed 2 appeals, one of the judgment for possession and one of the order ordering him to pay $1,800 per month. The $1,800 per month order ultimately was heard, a review of that was heard by a single justice in December 2018, at which point the single justice did reduce the payment to $500 a month, but also referred 5 questions to the panel to be answered, some of which went to the issue of to what degree Mr. Branch's indigency or lack of ability to pay should factor into what Mr. Branch should pay for use and occupancy. Shortly thereafter, my client had the misfortune of buying this property from Fannie Mae, and although arguably he clearly should have known the mess he was getting into, he didn't.
What,
He did not.
what month and year was that?
That was December. That was December 18, and I think the deed was recorded in January 19. Why there was a delay in recording the deed, I'm not really sure. Right as we speak today, but January 19, I think, is when the deed was recorded, or thereabouts. After the deed was recorded to my client, Fannie Mae filed a motion to get out of to dismiss the appeal based on the fact that it was moot, which was denied. When that motion was denied, Fannie Mae agreed to have the $500 per month use and occupancy payment vacated. That occurred in March of 2018. Mr. Branch paid 1 or 2, maybe 3, I'm not sure exactly how many, $500 payments of use and occupancy. Where those payments have gone, I don't know.
So
But he
are
has
you
not
saying
paid.
that since March of 2018, there's been no order for use and occupancy payment?
That's correct.
Okay,
That's correct. And no payment for use and occupancy. My client, it initially started a summary process case because he was unaware that all of this stuff was pending with another attorney. And when he found
did he
out,
do a title search before he bought the house?
he was represented by a lawyer who didn't do a very good job. But
That might be
he
the
was unaware,
understatement of the day.
and because he was unaware, he started a summary process case against Mr. Branch in the housing court. And when he realized that all of these things were pending, he dismissed that case because there was already a judgment for possession against Mr. Branch, and moved to intervene in the case that Fannie Mae had against as an intervener, as the real party in interest. His initial effort to do that was in the housing court. It was denied because the appeal was pending. He then filed a motion to intervene in the appeals court, which was allowed.
And what month and year was that?
That was it was, I don't know the exact month, but it was in the summer of 2019 rather.
19.
Yeah, August 26, 2019.
All right, so March of 18, the use and occupancy order is vacated, and then there's nothing really until 2019 when this court allows your client to intervene in the appeal.
Correct. The appeal then came before the panel, and I'm sorry, I'm not prepared to tell you the exact. Hold on, I can tell you.
That's okay. I have that decision.
Okay, and when the panel considered the case, they determined based on the fact that cases such as Davis versus Comerford and Bank of New York versus Mellon had been decided that the 5 questions which had been referred to it were moot, but allowed my client in the meantime filed a motion for use and occupancy with the appeals court, and the appeals court remanded it back to the housing court, authorizing the housing court to hear a motion for use and occupancy from my client, which was then filed, ultimately resulted in a hearing on September 21st, and the court issued the order which you're considering today.
So was there ever a $1,000 a month order before the September 2021 order?
No.
Okay, so it was 1,800, it became 500, it was vacated, and then September of this year, which is why we're here today, it was 1,000.
Correct.
Okay.
And it's important to note, Your Honor, and I understand that his lawyer didn't do a very good job, but my client has carrying costs here. Mr. Branch has lived in the property since at least June 12th of 2017, having paid maybe 2 or 3 payments of $500 for use and occupancy. Regardless of his financial condition, that is not justified.
What
Mr.
do you
Branch,
say about
if he had not been
Mr. Branch's
foreclosed,
claims, counsel, what do you say about Mr. Branch's claims that the notices were non-compliant?
I would just say that that's, they're claims that he's throwing whatever he can against the wall to see what sticks. He has taken advantage of the situation. He's lived rent-free for many years. He occupies the property, and under the factors that are clearly set forth in Comerford, if you read the court's decision, the lower court's decision, they're carefully considered. The factors are considered and applied. The fair market rental value of this property is $2,300 per month. Mr. Branch provided no evidence at the hearing as to what he thought the fair market rental value was. He did present photographs that reflect that the property is in defective condition in certain areas. The judge rightfully suggested that he allow my client access so that those conditions be repaired. After the judge issued the order that he allow access, Mr. Branch denied access. Mr. Branch suggests that the judge had no right to suggest that my client have access to the property to repair the conditions that Mr. Branch suggests reduce the fair market value of the property. But as the owner of the property, has a right to access the property to repair it. Mr. Branch denied that access, yet at the same time complains that the conditions that he's complaining of reduce the fair market value of the property. That too is not fair to my client. Mr. Branch should be ordered to pay something reasonable for use and occupancy. I honestly think that the lower court was generous in only ordering $1,000 a month. The fair market value of similar living facilities in the Brockton area is $2,300 a month. My client would like to repair the conditions and put the property in proper condition so that so that he can collect the fair market value of the property while this is pending. And Mr. Branch is denied access.
So the only appeal that's pending now is related to the current use and occupancy? Or is the appeal of the eviction pending?
The record was just assembled on the.
Okay, and that was the order where I read that the housing court was waiting because of what the appeals court was doing. So that's now been assembled.
Yes.
So
Yes.
that can move forward. Okay.
Yes.
It's a different kind of procedural posture.
Right.
Do you want to comment on the bankruptcy claim that Mr. Branch made?
I'm not really. He says that there was some agreement in the bankruptcy that I haven't seen the agreement.
Okay. All right. You still have 3.5 minutes or so.
Okay.
So is there anything else that you'd like to tell me?
The bottom line is this, Your Honor. Mr. Branch occupies the property. $1,000 is a very small amount of money in today's world to live and pay for a place to live. My client is paying the real estate taxes, and all of the carrying costs. He has not had an opportunity to maintain the property in the approximately 3 years that he's owned it, because Mr. Branch has denied access. But if he did, he would also have maintenance costs, and of course, those costs are increasing as the property deteriorates with him being denied access. I would ask that you at minimum affirm the lower court's order, and I would suggest that you read it. I think it's a very well written report and opinion, and it clearly considers the law as applies today, which, by the way, the cases that it's based on were not in effect at the time that the single justice ordered the $500, and the single justice reduced the order to $500 so that the court can consider the 5 questions which have subsequently been answered. And Mr. Branch's financial condition is just one issue of about 12 that should be considered. And I would ask that Your Honor consider that.
Thank you, counsel.
Thank
All
you.
right, let's wait for the clock to get restarted.
The clock will begin whenever we are ready.
Thank you. Mr. Santos, so how do you pronounce your name? I'm so sorry.
That's okay, Your Honor. It's Santo Lucido.
Okay, Mr. Santo Lucido, finally, I think I got that right. When you are ready, the clock will begin. Thank you.
Thank you, Your Honor. Thomas Santalucito for Federal National Mortgage Association, better known as Fannie Mae. As the trial court's decision correctly notes, my client takes no position at all concerning Attorney Stammen's, Mr. Cardoso's request for use and occupancy. As I think the parties are in agreement, Fannie Mae sold the property or its interest in the property to Mr. Cardoso in December of 2018. After that time, my client no longer has an ownership interest in the property. It's no longer entitled to possession or any ongoing monthly payments for the duration of the case. That's why my client asked the panel previously to dismiss the appeal, that the issue was moot. My client no longer had any interest in the ongoing payments.
Because we allowed the intervener.
That's correct.
Once we allowed the intervener, Fannie Mae was essentially done.
Yes. Once Fannie Mae sold the property, essentially, it was done at that point.
That's
Again,
true.
it no longer has any ownership rights in the property, and as such is no longer able to collect any payments from Reverend Branch. And as such, it requested a panel of the court dismiss the previous appeal concerning this issue of use and occupancy. So again, just to sum up very quickly, my client takes no position on the issue at all and leaves the court to make the determination based on the other arguments you've heard.
All right. Does that conclude your presentation, Mr. Santo Lucido?
It does. Thank you, Your Honor.
Gentlemen, thank you all very much. I'm glad that we could do this by Zoom, especially with COVID still raging. I will read everything carefully.